Yo, what's up, everyone? It's Evan with Lions, Bulls, and Bears, back for the first episode in a while. Tonight's episode is going to be about the SEC versus Ripple, the trial of the century, as it's being called, and we'll discuss what it means for the whole crypto space at large, as well as what it means for Ripple Labs and for Brad and Chris. And let's talk about it. All right, so let's get into it. The SEC attacks crypto, and the battle rages on right now. Thought I would give an update since there was some information that came out today, and we'll get into that in just a second. But I wanted to kind of go back to the beginning because I've actually been taking notes on this for like 3 months now in this video. I've been wanting to put this out, but every time I get ready to record, there's just more information that comes out or other things I think about adding in, and so finally doing it before the whole thing's over and ends in a settlement. But we could still be months and months out, and they might not settle. It might go to court. They being Ripple Labs, and also Brad Garlinghouse and Chris Larson are both being sued individually as well. So let's go back to the beginning. I want to play this clip from Pomp's podcast when he had on Brad, and let's listen to what Brad says here.
But what would the challenge to the business be if it was deemed a security?
Well, look, I mean, I look at it as one member, and Ripple's an important member of the XRP community, that it is my very strong opinion that it's very hard to look at XRP as a security. I've made lots of points publicly about why that's the case.
I didn't think you'd changed your mind on that, but I just wanted to give you the opportunity if you did, but go ahead.
Fair enough. I think if XRP were deemed a security here in the United States, that, where you have other major G20 markets that have already taken a different view, it's kind of like, I'm not aware of any market globally that thinks XRP is a security. And so, you think about it, all right, so why would we here in the United States want to make a decision that's out of sync with other major G20 markets? Why would we want to create an uneven playing field that advantaged these Chinese-controlled technologies?
All right, on the drive home now, and a lot of people were criticizing Pomp for this interview. Thought overall it was pretty good, and hopefully once the lawsuit's all settled, they can do it again. I like both Pomp and Brad, and I think they both brought up good points. And so Pomp did a good job of just getting straight to the point, asking what it means if XRP gets the label of a security, and Brad responds with saying it would put the U.S. out of sync with the rest of the world, and I think that's a valid point to bring up. It doesn't really matter too much because Ripple's a U.S.-based company, and the investors, the SEC, are trying to protect our American investors, and but jurisdiction is an issue in this lawsuit and is being brought up. But it also, I think does hold a little bit of weight, and the Judge Torres might consider what other countries are doing. Pomp, later on in the interview, Pomp digs a little more, and listen to what Brad says here.
let's go all the way back for a second. Hold on. So if XRP was deemed kind of a negative ruling in your opinion, then really what it does is it might not necessarily hamper your ability to operate globally, but definitely in the United States, it would drastically change the way that you can operate, if not even make it nearly impossible to do it based on how the system's built today?
No, I mean, that's too far.
Okay.
Meaning, like, look, a lot of what Ripple does today in the United States, we could continue to do no problem. A component of what we do today is, our customers of ODL or on-demand liquidity, they buy XRP from us. If in fact, then that is a security, we would have to get a broker dealer license. Anybody who's buying and selling XRP in the United States would have to get a broker dealer license. The reality is what we would probably do is just say, okay, in order to provide certainty and clarity on a go-forward basis, we would want to look at other markets, other jurisdictions where there is that clarity. And earlier in this conversation, I highlighted the UK, I highlighted Japan, I highlighted Singapore. These are all markets where you do have that clarity where you can operate with certainty, and Ripple could keep moving forward. And I mean, frankly, most of our customers are non-US customers by a long shot today. And so we could absolutely continue to build the business and grow. We would no longer be a US taxpayer. We paid, I don't know, probably order of magnitude, $200 million in taxes here in the United States. And I just think that it doesn't serve, I think, the US agenda to drive us offshore. More than 90% of RippleNet customers are outside of the United States.
Wow. That's a huge number.
All right, so Brad mentioned a couple things there in response to Pomp's question. Number one, U.S. companies offering XRP still would be able to. They would just have to get a broker-dealer's license. Number two, it could drive them offshore, which would potentially give another country an advantage and be a tax blow to the U.S. And number three, that a majority of their customer base and volume, over 90% of both of those come from outside the U.S. So I think those are also some very valid points to mention. So, and to keep in mind about XRP, just to give some context that this is just one country, albeit a very important country, the United States, but still it's just one country, and this is a worldwide issue of moving money, cross-border settlement, and so the use case Ripple is going after, which is the most important one, really. So one of them. So yeah. Anyway, also wanted to play this clip of Brian Brooks a while ago talking about regulatory clarity coming, and I think this lawsuit is part of the regulatory clarity that he was talking about. And also I want to play a clip from the journalist who called this the trial of the century. That wasn't my title. This is really a big deal, and I'll read some of tweets by Stuart Alderati. He's been saying about how this could be the new standard instead of the Howey test for digital assets. And yeah, as well as read Brad Garlinghouse's response and Ripple's response from when the lawsuit first dropped. So here we go.
But what we do need is clarity about what's allowed. And so we need some guidance, for example, about whether banks can connect directly to blockchains as payment networks. The answer has to be yes, right? We needed answers about, can banks custody cryptocurrency so that institutions felt comfortable adopting? And you saw what happened when we gave that clarity. So you have clarity across a variety of areas that I think you'll be seeing just in the next 6 to 8 weeks, which will make it easier for crypto investors to know how to invest, to know how institutions can be in this asset class. And those are the things that are driving prices at this point. It may have hit a bubble 2 years ago, but with more clarity, institutions that see this as a real thing are going to adopt at scale, which they've already
Should we be
started.
expecting some new regulations by the end of the Trump term?
I think you're going to see a lot of good news for crypto by the end of the Trump term. Some of it's going to have to do with banks connecting to blockchain. Some of it's going to be more clarity around the nature of these assets. But nobody's going to ban Bitcoin. Nobody's going to ban some of these transmission technologies. I think it's going to be a lot less bad than people.
Regulatory actions carrying over to the Biden administration. While I have Dr. Layton, I'm going to start with you. I figure you're still fresh, so we'll go. You recently wrote a piece for Forbes in which you called a recent lawsuit by the SEC against Ripple Labs the cryptocurrency trial of the century. For those in the audience who may not know, the SEC filed a lawsuit last month against the software company Ripple Labs, alleging that the digital token it developed and uses in its software, XRP, is an unregistered security. What makes this the crypto trial of the century?
Well, at the issue of this case, I think is looking at Ripple and XRP. The XRP, as the question is it a security or is it a is it a currency or a security? That is the $1 trillion question. And what's so fascinating about this is that the other digital industries are engaged in these same kinds of fundamental administrative law questions. We have it in telecommunications where, is a service information or is it communications? They're both. They're very challenging. And for economists, this is a fascinating thing. We talk about all the wonderful things that these evolved assets bring to us, all the economic growth, the efficiency, all of the innovation that it creates. But if you're a lawyer, it really matters if it's one or the other, because it decides which regulator is in charge. And that can be, birth or death, depending upon what's at issue. I have gone into detail on this case. What concerns me about it is the contradictions between the regulatory agencies. There's a free-for-all deciding, who's getting to regulate this, and it's clearly something that Congress should be deciding, not the regulators themselves. Contradictions in the international arena, with multiple countries accepting Ripple as a currency. They've been operating under the Treasury and DOJ frameworks for more than 5 years with this determination that it's a currency. So that I find is very disruptive itself. This is regulatory disruption that's needless. I think there could be other ways you could go about it, other sorts of notice and other kinds of investigations where you could make this determination instead of just flat dropping a lawsuit, at the end of a term, for example.
All right, so that journalist, her name is Rosalind Layton, and she's a senior contributor for Forbes. And I think the point how she mentions the timing of all this on Jay Clayton's last day, was not, productive, and that, this regulation through enforcement idea isn't the best either, very productive also. But definitely check out the whole article. I'll link it down below. And I thought Brian Brooks made a good point when he talked about, he mentioned that Bitcoin and some of the money transmission technologies won't be banned. And I think that he's referencing Ripple and Stellar specifically right there without naming them, but he could be referring to something else. But yeah, I just feel like Jay Clayton, a lot of people in the XRP community think that this whole lawsuit is theater and that it's all a stage. now we got Gary Gensler coming in as Biden's pick. And I think even if the conspiracy theorists are right and somehow we see a return of Trump, then we'll still get someone like Hester Pierce or someone who's still pro-crypto. So it'll be interesting to see what Gary Gensler does about this case. And also on the point, I forgot to mention about when Brad was talking about jurisdiction, Ripple moving to more friendlier jurisdictions. Ripple just barely recently moved to Wyoming, where they have more, friendlier laws for blockchain companies, and a more friendlier environment there. So they are now a Wyoming-based business. So Ripple moved to Wyoming, and that has a lot to do with Caitlin Long. I'll also, when I get into Stuart Alderoty's tweets, I'll also read a tweet by Caitlin Long. But first, before I get into Brad's tweets, Stuart and Caitlin's tweets, let's listen to one more clip of Brad on the news after the lawsuit was announced.
Brad Garlinghouse, the CEO of Ripple, for a first on CNBC interview. Brad, welcome. Good to have you with us. And this is an interesting story. I'm going to pick up where Kate just left off, which was the idea that investors may have thought that in buying XRP, they were buying a security that gave them shares or some ownership in Ripple. Why is that wrong on its face?
Well, first of all, Tyler, thanks for having me. I think this is an important issue. And I think there has been confusion out there. Ripple, the company, as Kate introduced, we have shareholders. We've raised capital from venture capitalists, from actually institutions, and even banks like Standard Chartered is a shareholder. XRP is a separate thing altogether. It is a currency that trades in the marketplace. In the last 8 years, over $1 trillion of the currency has traded. And so what we find is, the SEC, in my opinion, having watched this for many, many years, taking a position now that is, frankly, I think, with one foot out the door, a little bit incredible to kind of take the position after 8 years. It's certainly, I think, one of the ironies of all of this is that for XRP to be a security of a company, the company has to exist. And the point that I have made at various times is that if Ripple, the company, didn't exist, XRP would still thrive around the globe with, a couple hundred exchanges around the world. And there's over 100 different projects, innovative entrepreneurs here in the US and around the world, building on top of XRP.
So Brad mentioned that XRP isn't a security of Ripple because they already have a security of Ripple. You could own shares in Ripple. They have shareholders. And that's kind of confusing that if XRP is a security of Ripple, that there's like two securities of Ripple, and how also could XRP be a security of Ripple if Ripple were to cease to exist, that XRP would still be functioning and being used. So those are two arguments Brad's being made by Brad. Also, in the following clips, you'll see that he's trying to make the case that there's not a difference between Ethereum and Bitcoin and XRP. So let's listen to that, and how not only that this lawsuit and the lack of regulatory clarity is stifling innovation in the US and is the government picking winners and losers, according to him. So let's roll that clip.
Well, about 2.5 years ago, a little over 2.5 years ago, the SEC came out proactively and said they did not view Bitcoin as a security. They viewed it as a commodity or currency.
Shortly thereafter, they came out and said Ether, the second most valuable cryptocurrency, is also not a security. They then have spent the last 2.5 years going after kind of enforcement by saying that certain initial coin offerings were securities offerings. Actually, I've spoken out in favor of that because I think in many cases those were in fact. XRP, however, is almost undistinguishable from what is Ether in terms of its decentralization, in terms of the breadth of activity. It's traded on a couple hundred exchanges around the world. And what's amazing to me is not a single other current country anywhere has looked at XRP as a security. One of the reasons why I view this as something that's broader than just, hey, what does this mean for Ripple and XRP? It's what does this mean for the crypto industry here in the United States? The SEC is really picking winners. They're saying there's a duopoly of Bitcoin and Ether are the two digital assets, the cryptocurrencies that will be not regulated by the SEC here in the United States. And it really, I think, sends an ominous sign for innovation around cryptocurrency in the United States. Picking winners in general has not been something the U.S. government should be in the business of doing.
I also wanted to mention that two YouTubers that I like their work a lot is Chico Crypto and Bix Weir, and both of those guys don't like XRP very much, and they're both, I think, really smart when it comes to the crypto space. I mean, Chico's a genius when it comes to this whole sector and technology, and Bix knows a lot about banking and money and monetary history and economics, and he also has a really good, I think, grasp and a fair amount of knowledge about on the technology side as well. So, you know, when both those guys talk, I listen. I watch every video of theirs. So, big fans of both their work, and they both think you know, this lawsuit isn't really good for Ripple, and let's hear what the XRP haters gotta say. And again, I don't say that condescendingly. They, you know, don't like XRP, so you know, they're both smart. Also, I'll throw in a clip from Tone Vays, another person I like, and who's, you know, Bitcoin maximalist, but I like Tone, and so let's hear also what he has to say. So
they're getting hit with the lawsuit, and the litigation has begun being filed. The evidence mounted against Ripple, it's fierce, and this time precedent could be set as the lawsuit it is in federal court with the SEC. The outcome, it will have ramifications for not only Ripple, XRP, and those involved, but those that fall within this security basket. And this case will decide which ones do fall into that basket. The precedent, it will be set. Well, the case, it is happening. The pretrial has been set, and as we can see from the court filing, this pretrial conference takes place on February 22nd. So what's going to happen here at the pretrial conference? The lawyers usually appear at the hearing before the judge without their clients, and they try to agree on the undisputed facts or the points of the law.
Ripple is in serious trouble. People are starting to read the SEC's case, and it's pretty damn solid. Something that I've been saying for, I don't know, 5 years maybe, God knows how long. And the SEC finally put the case together. It took them a while, but they finally did it. And therefore, everything else is now in jeopardy. The SEC was supposed to put together this kind of case for Ethereum. Instead, the idiots at the SEC decided that Ethereum is decentralized, which it's not. So they didn't want to screw up twice. So they didn't want to mess up Ripple.
Besides BTC, Ether is the only other digital currency the CFTC has publicly stated is a commodity. And this view by Gary's former division was just reinforced in December when CME, the Chicago Mercantile Exchange, confirmed Ether futures would launch in February of 2021, aka next month. CME wouldn't funk around if Ether didn't have the green light. But what are Gary's own views? Well, he gave a lecture called Smart Contracts and dApps, which of course included Ethereum, but also his thoughts on if he thinks it's a security. Let's listen in.
Bitcoin started in January of 2009 and nobody owned any Bitcoin, whereas Ethereum started with a pre-sale and an ICO, which we'll be talking about 72 million Ethereum. Vitalik wanted to raise money. He was maybe 19 years old. He looped in with a venture capitalist from Canada, Joe Lubin, who now runs Consensus. Lubin took about 10% or 9.5% of the offering. They put 9.5% in a foundation called the Ethereum Foundation, and the other 80% was sold to the public for $18 million. We'll talk later in the semester as to whether that was really a securities offering. I've publicly said I think so, but that was in 2014, and in 2018, the Securities and Exchange Commission has said, regardless of what it might have been in 14, it's now sufficiently decentralized that we'll consider it not a security.
Like, this is going to be bad. And there's going to be a mass exodus out of shitcoins because they don't know who's next. None of these investors in these shitcoins know who the SEC is going to go after next. I think Monero and Litecoin are safe, but anything else other than Monero and Litecoin, they can do the same thing to them. All they have to do is collect the evidence and put it together in a docket. So because no one's going to know who's next, they're going to be selling those bags for Bitcoin, because once the news breaks,
the regulators' sites and who are not in the sites of those gosh darn regulators. So the big obvious one should be, if the altcoin ran an ICO, it raised funds from the public, especially US investors with no KYC, they might just have a big old target on them. And I'm being fully transparent about the ones who did it in the top 10. The information is out there online. Binance Coin, no KYC, money raised from the public and most likely US investors. Chainlink, no KYC, money raised from the public and most likely US investors. Polkadot, KYC, so they stopped US investors, but money was raised. Cardano, also like Polkadot. So 40% of the coins in the top 10 may have some questions. Although Chainlink and its token within its network of oracles obviously has utility, thus it's nothing like XRP, which was a pure fundraising device with no utility.
There was nothing behind XRP. XRP was not a banker coin. It was started by 3 guys who were in the banking business who saw an opportunity to make a hell of a lot of money. Not to save the banking system.
And that's what would happen. Like, if the Ripple token is deemed a security, which it is a security, it would have to be delisted from every single unregulated platform. And they would have to list the token on the New York Stock Exchange as their stock, which would be weird because they're trying to go IPO to double dip in the equity space. They already have an equity. They already have a security, but they want another security. So $5 billion is not enough for them.
Just trying to stick a middle finger to the SEC is not going to work. Many tried to do it in the 80s and 90s and even the 2000s with Wall Street. They failed, you will too. So in my opinion, it would be good to settle and not get the laws written that have a really good chance of hurting the industry for good. So what's XRP trying to prove in court? What's their end goal? Well, the proof is in the pudding, and this pudding I'm about to show you. They're trying to cover all their bases, but first they're trying to make them the one cryptocurrency by law. Vitalik knows it. He tweeted about it after the SEC's complaint was filed. He said, "Looks like the Ripple XR team is sinking to new levels of strangeness. They're claiming that their Shatcoin should not be called a security for public policy reasons, namely because Bitcoin and Ethereum are Chinese controlled." Yes, that is taken from what they have said to the SEC as reasons for why they are better. That is their plan in court. It's going to be their narrative. And there is a strong likelihood that they lose. And XRP is ruled a security. So what was their plan B? Not Bitcoin, but plan F, Flare. Isn't it a coinkydinky right before this lawsuit, the Flare airdrop was pulled off?
What happened right before the SEC laid down this case, which they had all along. They could have nailed them for the last 7 years. But what happened right before is we had a huge pump in XRP so that those who bought in can get out. And they said, oh, there's going to be an airdrop. So it pumped. I hate to tell you, I called it, but I called it. Now people are saying, oh, it's just so that the big guys can get in. The big guys don't give a shit about XRP. The big guys can invent their own version of XRP in a blink of an eye. What we had was a massive fraud.
This was their token swap. If the lawsuit doesn't work out how they plan, where they are the rulers of crypto, they can still stick around with Flare.
Let's look at the distribution. XRP distribution, there's 100 billion XRP that were created out of thin air, right? 20 billion of them went to the founders. So 20% automatically went to these three guys. 7 billion went to Ripple Labs, which is owned by the three guys. 40 billion in public hands, that's 20, so it's basically, what is that? 13 billion. 13 billion were basically given to the public to say, hey, you can be part of the new banking system. You, the little guy's going to win.
Now the big question that needs answered is XRP, as I'm sure their army has been holding their breath regarding the new chairman. Well, sorry to burst your XRP bubble, but it isn't the best of news. Let's hear it.
So Hugo was asked about the token XRP and whether I think it's a non-compliant security. I've spoken publicly. Yes, I do think it's a non-compliant security. But this will not be resolved just by the Securities and Exchange Commission. It will be resolved by some courts, whether it's appellate courts or the Supreme Court. So what I believe is just that. It's a belief. But why would I say that? I think back to the Howey test. I think they are exchanging XRP. Ripple, the company, is exchanging XRP for something of value. And they're using it right now. They sell it every month. It's in a lockup. There's in an escrow. And they sell XRP every month. Ripple, the company, initially did the Genesis block back in 2013, but kept 80% of the tokens. Now they have about 60% of the token.
He has a strong view that yes, it's a security, and thanks to Leonidas on Twitter for putting this together, but the lawyers have been set for both the SEC and Ripple, and it's a long list of lawyers on the XRP side, as they are obviously going to need it, with the SEC confirmed to be aiming to be moving full steam ahead with a security ruling. So that court battle, it will rage on.
Right, so now that we heard what the XRP haters had to say, now let's hear what the XRP army has to say. I have to say some of these channels are some of my new favorite crypto channels. XRP Bags, XRP Chiz, CHIZ Chiz. Let's see who else. I'll link all these down and below. Crypto Airy, Kevin Cage, who else? Bank XRP, Digital Asset Investor, and Digital Perspectives, as well as Thinking Crypto, and yeah, I think that's about all of them. If I forgot any, I'll mention them when we come back. But let's hear what the people who are, big believers in XRP and Ripple, and get their take on the lawsuit. So let's roll those clips.
This is the Digital Asset Investor. And the big, huge, mega story right now, and everybody's all freaked out because the SEC is going to sue Ripple over XRP.
Let's start with this, because I really do believe what we're seeing is history in the making here. And I believe at this point, and it could change, everything is liquid, but I believe that this is the way it has to go. This is the way it has to go. This is a part of making history. Now let's talk about this, because this is talk about feet planted firmly on the ground. We are at 30 cents and currently falling like a manhole cover from the sky. It is down more than 35% right now, and you better have the stones to know what you hold, or you'll be jumping like paratroopers out of an airplane.
And I'm, just very skeptical of all of this, the timing. End of year, Jay Clayton leaves the SEC, a new administration is entering. Something just appears to be super fishy. Now, is it all coincidental? Is some of it orchestrated? And I still believe that a big part of the world is a stage.
I want you to think about something that I've said 1,000 times on this channel. It never made any sense to me, this idea that here's this startup. First of all, this startup that's going to be allowed to have their own digital currency, and then openly, not in secret, but openly, and put out reports and sell this digital asset all these years. Nobody does anything. They sit there and stare at it. They actually have meetings with them. Brad Garlinghouse has had meetings, I believe, with the SEC and the Treasury Department, okay? People from Ripple. There was a meeting where David Schwartz was with Brad Garlinghouse. And then out of nowhere, after 7 or 8 years, you just turn around and say, okay, we're going to charge you now. No, that defies logic. It doesn't make any sense. So the SEC charges Ripple and 2 executives with conducting $1.3 billion unregistered securities offering. According to the SEC's complaint, Ripple's Christian Larson, the company's co-founder, executive chairman of the board, and its former CEO, Bradley Garlinghouse, the company's current CEO, raised capital to finance the company's business. The complaint alleges that Ripple raised funds beginning in 2013 through the sale of digital assets known as XRP in an unregistered securities offering to investors in the U.S. and worldwide.
There's a lawsuit hanging over Ripple right now. A group of people are saying that XRP and Ripple are sort of tied together, and that XRP could be considered an unregistered security. What would you say to them?
Well, it's pending litigation, so I'll probably be a little bit, muted on the topic. Suffice it to say, we don't think it has merit. These are people who didn't buy XRP from us. We also don't believe XRP is a security. I think, one of the poignant arguments in my point of view is, if I went back to the office and said to the team at Ripple, hey, we're shutting down, XRP trades on 130, 140 exchanges around the world. XRP would keep trading. You're like, wait a minute, okay, so if it's a security of what? It's not a security of Ripple. It doesn't give you the rights to dividends or ownership of Ripple, the company. We have shareholders of Ripple, right? We raised a Series A financing, a Series B financing, and we own a lot of XRP, but they're 2 separate things.
So what's the difference between Block One and their token EOS versus what you guys are working on?
Well, I think one really important distinction is the XRP ledger existed before Ripple, the company. You can, it's a public blockchain. You can go back and see kind of transactions 0, 1, 2, 3. You can see when Ripple was incorporated in the Secretary of State in California. Ripple didn't create the XRP ledger. The XRP ledger had utility prior to Ripple's existence. Certainly we are an interested party in the success of the XRP ledger, for sure. We own a lot of XRP.
First off, I'm an ex-regulator myself. I work for the Federal Reserve at the Board of Governors in the payments group. And just my observation is, and again, I'm not a regulator now, but that just wasn't the way we did things at the Fed. You didn't launch litigation on the last day before the commissioner of your organization resigned, especially going into like a new administration. I mean, Ripple's been around for 8 years. There's been a long time to set clear rules, and then you could have arguments or discussions over what behaviors need to change to meet the rules. But to actually just file an enforcement action out of the blue on the day that you resign, so you're not around to actually take the heat for the consequences of what you've done, and then you just sail off into the holidays and a new administration. That's kind of an unprecedented situation. The question is, what was the reason after 8 years that required an urgent enforcement action just on the last day of under a particular particular leadership. And so this is a highly unusual situation just to start with in terms of the conduct of the SEC, independent of the substantive issues of the case.
It's very interesting to hear Jay Clayton talk about how his staff has hit this on the head. You know, everybody's blaming Jay Clayton, and yeah, the buck stopped with him, and he was definitely the person who put through that suit. I mean, he had to okay it. But as I have pointed out in the last two videos, when we really see who is driving this cyber group of investigators and attorneys that are taking it to the mat, it is definitely this Christina Littman. So I just want you to know that she was advising Clayton. She is the head of this group that is going after all of the crypto projects. Clayton believes this long-standing 80-year plus rule still applies, which is just, I think, a little crazy. And I think a lot of people are going to find it's also a little crazy because it needs to be updated. And should this Howey test now become the Ripple test, that's very, very possible. But you're going to see that he doesn't want to allow this cryptocurrency space to run out of his control. It's very, very obvious that he wants to exert, well, now he's gone, but he really felt the need to exert his power in this space. So I just think this is really worth listening to. Let's have a listen to the question that he gets.
As Harold suggested, and let's get the crypto. One of the maybe at the not the cutting edge, but the bleeding edge of fintech innovation during your time period at the SEC has been cryptocurrencies. Uncharted territory, which you've navigated with both those goals, investor protection, but fostering innovation in mind. Tell us a little bit about that journey as you've been chairman of the SEC, and give us some sense of where you think it goes from here.
Well, thank you. A lot of that goes to the women and men on our staff who hit this head on. But look, when we arrived 3 years ago, the promise of this technology was becoming readily apparent. Unfortunately, the promise got channeled into an area where we have long-standing regulations that have worked really well. And that is that you can't make a widespread public offering of securities without going through the SEC registration process. And ICOs and the like essentially flaunted that. And look, I don't blame people for being motivated to try and take a new technology and raise money using it, but I was not going to be the chair that threw the 33 Act out after 85 years of success. So there you have it. But that said, incredibly powerful technology for the financial sector. I mean, it's technology that greatly reduces the costs of verification. It's technology that greatly reduces the costs of information transmission. And it's technology that can drive some of the inefficiencies out of our system. So that's where we are today. Comply with the securities laws, but push the technology forward. And the area that is of particular interest to me and many of those regulators that Gary mentioned is the payment system. We all recognize that our payment system is inefficient. Domestically, it's inefficient. Internationally, it's extremely inefficient. So if we don't work and use technology to address those inefficiencies, the market is going to do it for us.
I believe this is political theater to get rid of the XRP investor from holding XRP, amongst other things, of course. Ladies and gentlemen, it's important that you understand that Jay Clayton also stated this.
Moving to a different issue, this year Facebook announced its plan to develop a new cryptocurrency called Libra. While the SEC is one of a number of regulators who would have jurisdiction over Libra, can you speak to how the Libra announcement has affected how the SEC and other regulators are working to be responsive to and innovative to market developments and trends like cryptocurrencies?
Sure. And I appreciate the question, and the question highlights what happened with that announcement. And whether it's, I'm not going to speak about the particular product, it's not appropriate for me to do so, but the announcement was a focal point for regulators of different types to recognize that digitization and the digitization of the plumbing and other aspects of our financial system, including payment transfers, et cetera, it is coming. The, what I'll say, just the natural economic forces that it unleashes, taking fat out of the system, for lack of a better term, it's happening. Now, we have to recognize that that's happening, recognize our mission, safety and soundness, investor protection, fair markets, and ensure that as that digitization takes place, we're being true to those principles. But we should not be fighting that digitization, because if we fight it, it will go around us.
The SEC is extremely incompetent. The SEC does not have the resources to combat a multi-billion-dollar company with the powerhouse lawyers Ripple has. The SEC does not give a shit about retail investors because they obliterated 65% of our investments value due to the speculative accusation they made that XRP was a security. It was grounded in no facts and speculation. The SEC's previous administration, this man Jay Clayton right here, was what was holding us back from being able to settle for years. I told all of you it was very suspicious that Jay Clayton slapped a lawsuit on Ripple as he was on his way out, so he had no way of defending it. And I think he probably did that on purpose, because with the contents of this case, we can see that he has absolutely no idea what he was doing. This was either a backroom coordinated way to accelerate XRP clarity, or this was the most poorly put together case by any administration in the history of the SEC.
All right. And as you go down here, this is what the most important part is, in my opinion. The SEC's complaint filed today in federal district court in Manhattan charges defendants with violating the registration provisions of the Securities Act of 1933 and seeks injunctive relief, disgorgement with prejudgment interest and civil penalties. Okay? This is the word that I'm most interested in. Disgorge. The word disgorge means to give up or reveal something on request or under pressure. Well, when I think of disgorge with in relation to XRP, what is it that could be revealed? And that could be the XRP escrow is what that could be. I believe that this is all about the XRP escrow.
Now that we heard what the XRP Army has to say, let's hear what some legal experts have to say. Because there's been some former SEC people, some former CFTC people like former chair Chris Giancarlo. Let's see, what else? Who else? Legendary, investors, top, banking executives and lawyers and judges and all sorts of people who have chimed in and shared their perspective. And so the main channel that's been doing an excellent job covering this is Legal Briefs. So definitely give that channel a subscribe. Jeremy Hogan, I believe is his name. And he has just been providing the most insight and clarity, and seems like a really level-headed guy. He deals with the SEC daily and is sharing his experience and wisdom with us all. So that's been really insightful and helpful and appreciated by me, at least. So let's hear what the pros have to say. So
the good thing is Gary Gensler gets XRP, he gets Ripple, he gets Bitcoin.
Ripple is a cryptocurrency.
type company.
And here the SEC is dead wrong. Former chair Mary Jo White defends Ripple in pivotal crypto case. So guys, you have a former chair of the SEC coming out saying this is stupid. What are you guys doing? In an interview with Fortune, White claimed the agency she once led made a blunder in suing Ripple for alleged sale of unlicensed securities. The sale in question relates to digital currency XRP, which was created by Ripple in 2013 and which today trades broadly in markets around the world. Here's a quote. "There's no way to sugarcoat it. They're dead wrong legally and factually," White said.
I think XRP is a security. I think XRP is a currency, and the reason why is when you think about the test that was laid out by the Supreme Court in 1946 in the SEC v. Howey, which is, you've probably all heard of the Howey test. It's a 4-factor test: investment of money in a common enterprise with the expectation of profits based on the efforts of others. And you have to satisfy all 4 prongs. So if one of those prongs is not there, you're not a security. So with XRP, Ripple could go away and XRP would still exist. And so there's no efforts of others in my mind.
That I think it's time to move on from this question of is it a security or not? Because right now the way the way the analysis works is it a security? And if the answer to that is yes, then sort of the entire weight of the federal securities laws and all the implications of that now apply to it. And my thought is that, maybe that does not have to be the approach. Maybe we could still sort of acknowledge that under the Howey test or under sort of traditional methods of analyzing, whether a particular instrument is security, maybe that shouldn't be the end of the analysis. Maybe that should just be the beginning of the analysis. And once we have decided that, or once we've concluded that something is security, then the question is not necessarily let's regulate it out of existence, which I'm afraid sort of is what kind of happens with crypto right now. I think the question should be, okay, it is a security, but it's not like what we think of traditionally as a security.
Right.
It's not like a stock or a bond. It's not used for the same purpose necessarily. And that's the funny thing when you talk about crypto. There's obviously endless flavors of crypto, and there could be some that are very much like a traditional traditional security asset, but there's others that just aren't. And so I think the question is, what are the fundamental concerns under the securities laws, and how do we address those with this new asset class without imposing, sort of other aspects of the securities laws that end up making the asset worthless or not being able to be used for its intended purpose. So that can be done by the SEC. Mm-hmm. And if I had one criticism of the Clayton approach, it's that they didn't take that second step.
What comes out of this is clarity. Then that's great. And so it's not all bad. Like if what you get out of this is clarity, that's great. And to some extent they picked on Ripple because Ripple's sort of the largest, it's the first, it's the biggest. And so if out of this comes clarity for all the other cryptocurrencies that are out there that do have a sponsor organization, well, that's a hell of a progress forward. And maybe the U.S. will move from being like the quagmire in this regard to being the leader.
If it is true that Michael Barr is my successor at the OCC, I think he's likely to have more of a thesis similar to mine on this. He has a background having spent some time on the Ripple advisory board, for example.
You worked at Coinbase, you worked in the government, albeit for under a year. So tell us, is XRP a security, yes or no?
Well, these are complicated questions and matters of pending litigation, so who can say? But here's what I would tell you, though, which I think is the most important issue about XRP, and that is there is a difference, okay? There's a difference between the way in which an asset is distributed and the nature of the asset at a given moment in time. And I think the issue in Ripple that gets lost in all of the discussion is whatever happened in the original distribution of XRP tokens, 10 years ago, and whether that was or wasn't an unregistered securities offering, that's what the courts will decide. That's a different question from whether XRP today is a security. And the SEC itself has said that assets can change their nature over time as they achieve utility and as they achieve decentralization. So if I had to make a prediction, I'll just make a quick prediction, and that is that there is a settlement to be done here somewhere, and the settlement has to do with the distribution of the tokens so that existing token holders can continue to trade them and find value in them the way that they do.
Okay, so an amended complaint was filed in the Ripple lawsuit. So what happened was that the SEC did not do a good job of alleging in the original complaint that the individual defendants had the legal scienter to be sued. So for example, the SEC added to the amended complaint paragraph 110, which says, quote, Larson and Garlinghouse both played significant roles in negotiating and approving Ripple's institutional sales and other offers and sales of XRP to institutional investors, close quote. So that is a new allegation that is pretty typical of the new complaint. This amended complaint was kind of heralded by the letter to the judge last week, where the parties told the judge what contemplated motions were out there. That's in, I think, subparagraph 2 of the letter. In short, what happened was that the lawyers for Garlinghouse and Larson told the SEC that they were going to file motions to dismiss the lawsuit against them. And the SEC said, well, okay, then if you're going to file a motion to dismiss, we're going to go ahead and amend the lawsuit in order to try to avoid your motion to dismiss, and therefore they got the amended complaint done, and they put in a lot more facts showing how Garlinghouse and Larson were personally involved. I still think there will be a motion to dismiss, but I think the individuals will probably lose those motions because I think there's enough facts now in the lawsuit to keep them in the litigation. And that's bad for Ripple because Garlinghouse and Larson are obviously high up in Ripple and will decide what Ripple does. And until you've been sued by the federal government, you have no idea how stressful it is. I mean, it's the kind of stress that leads to sleepless nights, tears. You can't concentrate, you can't enjoy time with your kids. It's horrible to be on the end of this kind of lawsuit, and it's going to affect what Ripple does because Brad and Chris are obviously high up in the Ripple hierarchy.
Well, first of all, I am not an official, and so I am not speaking in an official capacity. Ultimately, it'll be the courts that will determine this. I am now a practicing lawyer. I'm with the firm of Wilkie Farr and Gallagher. Ripple is a client of the firm. What we did in a scholarly piece in a law review was to analyze Ripple against the well-known Howey test, which is the Supreme Court's determination of what is a security, and based upon a legal analysis, concluded that it's not. Now, you'll note in that piece, it's a legal piece. It's not a advocacy piece. It's not a policy piece. It's a straight legal analysis.
A lot of institutions now are coming in and saying that they need more clarity around custody, for example. Investment advisors and broker-dealers trying to deal with this, trading platforms thinking about trading these things. So I think there's a greater appreciation of the interest in this asset class. But I think we still face the challenge, right, that all of this meets the traditional securities laws, which are designed purposely to be very open-ended.
Sure.
And the goal there is that we want to make sure that anytime someone's going out and saying we're raising capital to build something, that we're capturing that within the definition of security. And so the definition in the US is a lot more broad, maybe, and less constrained by clear lines than it might be in some other places.
Is there a dialogue happening about that? Well, we need a Howey test 2.0.
Well, there's a dialogue, but sometimes I feel like I'm a little bit dialoguing with myself. So, I mean, I think people are starting to realize that, and I can't speak for anyone else at the SEC, so I just underscore that. I think people are starting to realize that, but at the same time, the Howey test has worked relatively well over time in a lot of different contexts. And so it did take me, when I first came to the SEC, I looked at it and I said, you know what, Howey should be able to accommodate crypto as well as any other kind of asset class. It took me quite some time before I said, you know, I'm not so sure that we can use the framework that we've used for everything else for crypto. And in fact, I'm not even sure that the kinds of disclosures that you get in a securities offering are really the kinds of disclosures that a purchaser of a token would want or need. And so I think that this is a conversation that I want to have with Gary Gensler, if he's confirmed, to just say to him, look, I think we need to do something here because I think there's something different about this space that makes it uniquely difficult to try to use the Howey test.
How do we get all these agencies to be on the same page?
Well, so generally, each agency is bound by its statutory framework. We have our set of statutes. CFTC has its set of statutes, and just because something is one thing for one particular agency under its particular statutes doesn't mean that it's not something else under some other agency's statutes and rules. So it can be pretty difficult to try to herd all of those agencies. So I think that an idea is to have a sort of cross-agency safe sandbox that would allow people to come in who aren't sure which agency's jurisdiction they might fall under, and allow some kind of experimentation. I don't think it will be easy to design that because of the fact that some of us are these independent regulatory agencies and others are executive branch agencies, but we do work together all the time. Treasury does a good job of coordinating work across different agencies in the financial regulatory area. And so I think there would be a possibility of doing that. We also work together with our international counterparts, and a lot of that work is just trying better to understand, how are you approaching this issue? How are you thinking about this? And I think that kind of thing can be valuable too, especially because a lot of these projects involve US persons, but also involve people in other countries. And so trying to come to some kind of common understanding of how we're going to deal with these international networks could also be helpful. But so there's no really magic bullet to solve this for everyone. Obviously in some cases it's so obvious that there was just outright fraud that it's in everyone's interest for us just to bring a case, and often those projects dwindle to nothing anyway because the people who were doing them just wanted to get the money and run. They had no intention of building anything. But it's a much harder question when you're talking about a project that actually is trying to build something, but we come in later and say we think that you did a securities offering that was illegal.
Well, you mentioned the SEC case against Ripple. What do you think is going to be the outcome of that, and what are the implications for the industry?
We'll see. I mean, the SEC obviously worked long and hard on that complaint that they filed in court. It's a well-drafted complaint. I think there are problems with it and fallacies in their argument. But ultimately, the courts will decide this. And I guess it's possible that the incoming chairman, looks like it'll be Gary Gensler, I guess he could withdraw the lawsuit, which has happened at some other agencies with the incoming administration with respect to other issues and other lawsuits. I don't know that that's likely to happen, but that's a possibility. But if not, the courts will adjudicate this issue. And ultimately, it may well go to the Supreme Court. And the one particular test that the SEC is relying on is an old Supreme Court case that goes back 50 years or so, the Howey decision that we all know with its test on as to whether an investment contract is a security or not.
Yes, I attended the pretrial conference for you, and we learned some very interesting things, and I would say one bombshell. The judge started by asking the SEC for its position. I listened closely to how the question was formed, and in my notes, I highlight that the judge said digital asset or cryptocurrency when addressing the topic. Judge Torres is a Harvard grad. She is very bright. She used both the preferred term of the SEC, digital asset, and also the preferred term of Ripple, cryptocurrency. So she's not showing her hand yet, but staying very neutral. So the SEC made its case first. It was attorney Tenrero, and in about 3 minutes, he made his case, and it quickly became clear to me that the SEC is primarily going down the road that I've been talking about the last couple of weeks. They are focused on the representations and expectations that were made back in 2013, 2015. Think about the SEC argument, but the best way to argue what they want to argue, that something is an investment contract, is to show the court the contract itself. Here it is. This is the contract. That's the strongest argument. Now, that's of course the best option, but apparently the SEC doesn't have that argument, or it's very weak, because they are going with option number 2, which is to show that Ripple talked and marketed XRP like it was a security. Ripple's presentation was even more interesting and included our bombshell, I think. Attorney Seresny spoke for Ripple and really went down Ripple's strongest arguments and took much more time than the SEC did. First, the attorney argued that XRP is a decentralized digital asset and it has been fully functional for 8 years now. In fact, in the past month, the attorney said that there have been $66 billion worth of transactions utilizing XRP, and most of them, repeat, most of them did not even involve Ripple at all. Second, the lawyer for Ripple noted that FinCEN in 2015 found that XRP is a currency and that almost every other country in the developed world that has decided the issue has decided that XRP is not a security and that XRP functions more like Bitcoin and Ethereum, which the SEC has publicly stated are not securities. Next, the lawyer for Ripple noted that Ripple sold XRP as an asset with no promise that it would work to promote XRP, and that most sales of Ripple have been into the secondary market. Finally, towards the end of Ripple's presentation would be where it got very interesting new information. This is the takeaway for me. And apparently, what Ripple found out was that as recently as 2019, the SEC was approached by a large crypto exchange, or maybe exchanges, and asked, hey SEC, can we sell XRP? Is it a security? So we can't sell it. Please let us know. And the SEC did not tell them, no, it is a security, you cannot sell it.
What people need to know, technically what I filed is not a lawsuit. It's called a petition for writ of mandamus. I started drafting the lawsuit, but then I realized that you have to give the SEC 6 months before you can sue them. You have to give them proper notice, and then after the expiration of 6 months, then you can file what's technically a lawsuit. Obviously, with the exchanges delisting XRP or suspending it and halting it, I didn't want to wait that long. And I also, when I saw the complaint from the very first line said from 2013 to the present, that they were alleging that today's XRP in 2020 and 2021 is a security, I just still to this day have a hard time imagining an SEC attorney standing up in court and saying that the XRP and my Coinbase and Uphold exchanges are illegal securities and everyone else's XRP. So a writ of mandamus is when you're asking the judge to direct an officer of the United States to do his job. And so I technically filed the case when Elad Roisman was the acting chairman after Jay Clayton stepped down. And so I served him with the complaint, and it's asking the judge to order him to amend the complaint so that it only alleges securities in the earlier time frames where there were distributions, say between 2013 and 2017, because that's where I believe is the only chance the SEC has of being able to prove it's a security. And of course, I'm claiming that the SEC, by filing it the way they did, with the circumstances that they did it, that it was a gross abuse of discretion. And so the judge in Rhode Island could very well say to me that I have another remedy, that a lawsuit, and it's all about money, calculating the damages. You just have to wait. And he could say that that's an adequate remedy. I think the SEC, and I don't want to be too mean, but I think it's just in complete disarray. I think that Gensler is walking into, they can't even agree. They're writing public letters against each other and how to approach it.
All right. So now that we heard what the XRP haters, the XRP army, and the experts, the legal experts had to say, and the regulators had to say, I thought I'd share my thoughts on all that. So first off, everyone agrees. The haters, the XRP army, and the legal experts and authorities believe that this is going to affect the whole space. So XRP, Ripple getting this lawsuit over XRP is just the beginning. I mean, there are other obviously ones like Kik and EOS and Telegram and other ones that were already happened. And Chico brought up the point that he thinks that XRP or Ripple got sued along with all those companies, but they were able to delay. The one thing that Chico and Tone, the haters, disagree on is if Ethereum is safe and has the green light, and if it's decentralized. Chico says yes, Ethereum has gotten the green light, and that's true, and that's also what Brad Garlinghouse has mentioned. But now with their new 2.0, and Tone is saying that they might not be safe. So what will happen to Ethereum is also interesting too. But Chico is right that one of the main narratives that Ripple is putting out there is that there's two. Is that one, that it's not any different than Ethereum as far as the way it was distributed and the way its technology is used, the way its use case, and that also that unlike Ethereum and Bitcoin, which is centralized in China, Ripple is based here in the U.S. So XRP has gotten the green light in all the other countries, so it would be a disadvantage to the United States to classify XRP as a security or to drive them offshore. So let's see. Chico does a good job of showing clips of Gary saying that he thinks that Ripple, when they distributed XRP, was a securities offering. So that is problematic. It's funny how, everyone plays the clips that confirms their bias, because there are clips of Gary saying, calling it a currency and then, calling it a security. So it'll be interesting to see what happens when Gary Gensler gets confirmed. Let's see. So another point is Chico says sticking a middle finger to the SEC or trying to fight the SEC is not a good idea, that they should settle, and that if they try to fight them, they'll lose. The point I wanted to bring up is they don't always lose. So they win most of the time, but they don't always lose. I couldn't remember the clip, otherwise I would have included it, but Crypto Airy in one of her videos gave a example of a lady, and I can't remember her name and what company she was with, but she was advised by everyone to to not try to fight the SEC, and she fought and she won. And then also, even if they lose or settle, it doesn't necessarily mean the end of the world. Chico even mentioned EOS and how much of a negative effect it had on EOS as far as ranking and price. But EOS is still hanging on there and is still like one of the top cryptos, so it didn't end that project. And a lot of the arguments Chico and Bix make about XRP, I can make the same arguments about Ethereum or about Veritasium or about Bitcoin, so or about Chainlink, which at least Chico is honest about Chainlink being possibly in the sights of the regulators, because that's a project he likes a lot. And thanks, Chico, for turning me on to Chainlink back in the day, so that's awesome. All right, so Chico and Bix, I think, are wrong about Flare. I think that was just coincidental timing, but who knows, their assumption about Flare might be right. Assumptions, and I don't know, I think Bix is wrong about the big guys not giving a shit, as he says, about the little guy. I mean, I don't think he's wrong. I think he's right, but because even Brad has mentioned that the retail investor is not their target audience. Eventually, it's going to be the institutions and the banks who are going to be loading up on XRP. But there was this window period, these few years from XRP, when XRP got started until now, that the little guy did have a chance, and still does if you go to BitTrue or Uphold, to get XRP. And that's, you know, why a lot of people, you know, who've been saying for a long time, like the Bearable Bull, that XRP wasn't meant for the little guy. And now that they've been delisted from a lot of exchanges and it's harder for the little guy to get it, kind of lends a little credibility, but that could just be a coincidence to that whole argument. So I wanted to talk about, in one of Legal Brief's videos, he mentioned Gary Gensler is going to be very technology neutral, and it doesn't look like he's going to try to create like a new Howey test or a new test for this technology. So that's kind of, but I don't know, Hester Pierce in her video says she wants to talk to him about that, so we'll have to see. And lastly, Chico said about XRP's legal team that they will need it, and that's why they have such a big legal team, is because the SEC's case is so good that they're going to need it. I don't know, I just think XRP is prepared, which is a good thing. And they have, I mean, a former SEC chair, Clayton's predecessor, one of Jay Clayton's predecessors, as their lawyer. So it doesn't get any better than that as far as legal representation. So one person I forgot to mention about on the XRP, now we're moving on to the XRP. So that was all the haters, covered what they had to say. Now let's talk about the XRP army. One channel I forgot to mention was the Bearable Bull, which is one of my favorite channels. He's awesome, and especially when it comes to XRP and Ripple. So definitely give him a follow and check out his videos. The two top videos that I recommend to get caught up on this case is, I'll link them both below. One's on the legal teams and their lawyers. Speaking of XRP's lawyers and legal teams, he gives a full breakdown of every single lawyer and their credibility. And then the other one is like, I think it's 20 reasons why XRP will win, or Ripple will win. So yeah, those two videos are a must listen to, so check those out. I'll link them both below in the description. One thing I thought was interesting is that a lot of the XRP army was very frustrated about, as well as a lot of the legal experts that I mentioned, that I played clips from, mentioned how strange the timing was of all this, how Jay Clayton did this like pretty much on his way out, and how they waited 8 years. So that's pretty crazy. Brad Garlinghouse also mentioned that in one of the clips that XRP was not created by Ripple. XRP was not created by Ripple, and it had utility before Ripple, you know, even was created. So another thing I want to mention is Jay Clayton, and more specifically his staff, who it was his staff that went after all these crypto projects. Those people are gone now. So, and we got new staffers, new SEC chair coming in, and so it'll be interesting to see how the new SEC people handle where the last administration left off. So it's all up to Judge Torres and Gary Gensler. They're the most, two powerful people right now, that who's like the fate of XRP, of Ripple, of Brad and Chris personally, their personal lives, as well as the entire crypto space, really hinges on the decisions of these two people. And so Gary Gensler, Judge Torres, hopefully this all, like Greg Kidd said, hopefully we get clarity out of this, and it works out all good. And so yeah. Last thing I wanted to mention as far as the XRP Army is that Brian Brooks and Jay Clayton both, without mentioning XRP, keep talking about the exact use case that XRP and Stellar are trying to improve, which is the antiquated SIF system, the payment system, money transmission, cross-border settlement, all that. I think XRP and Stellar, despite any lawsuits or negative rulings or settlements that could come out of, I think will be okay and will play a role in the new coming financial system. So I think central bank digital currencies will use XRP and Stellar. So could be wrong about that. They could invent their own, like Bix said, they can invent their own, but I think Bix, like how I said, I can make a lot of these arguments about Bitcoin. I used to think that about Bitcoin back in the day, like, well, the government could just create their own Bitcoin. So, and that's kind of what they're trying to do with CBDCs, but I'm not sure that, you know, anyway, I don't think Bix is fully appreciating first mover advantage and network effect. So, you know, Ripple is established. They have, you know, major, you know, Bix says the big guys don't care about XRP. I mean, it doesn't get any bigger than Christine Lagarde, the World Economic Forum. I mean, you know, it kind of lends a little bit of credibility to it possibly being a deep state coin, like he says, because, you know, I'm not too fond of the World Economic Forum and Christine Lagarde and some of these central planners, but, you know, I don't have anything against them personally, just they're, you know, I don't agree with central economic planning. So, but yeah, at the same time, I acknowledge that I don't think the governments and central banks of the world are just going to throw up their hands and just say, oh, I guess Bitcoin's here to take over. We're going to stop trying to issue currency. So no, the central bank digital currencies are coming. How gold and blockchain will play a role is yet to be seen. So anyway, I just wanted to mention that Brian Brooks and Jay Clayton seem to be talking about XRP when they talk about money transmission services and payment rails needing to be improved, but I could be, you know, misreading that. So next I'll get into the legal experts, what they had to say. So first, I want to start off by saying you have a former SEC chair and a former CFTC chair saying that XRP is not a security. And I think in the case of Mary Jo White is saying that it never was a security. And I think Chris Giancarlo too. I don't think they ever believe it was a security, and that it's definitely not a security now. So that's interesting. Another thing I thought was interesting is what Hester Pierce said on Thinking Crypto's interview, is that, you know, usually the fraudulent projects dwindle to nothing anyway on their own, you know. So a lot of people were upset, saying that it was all a money grab. It was all just to, you know, get a bunch of money, to get rich, and to dump it on the retail investor. It's like, no, retail investor isn't even their target audience, and they, you know, I don't think, you know, all these major banks, MoneyGram, and would be partnering with a company that is just a money grab and if not actually trying to fix and solve a problem. So, you know, I could be wrong, but it seems like XRP is a legit project and the fundamentals are really strong. It may be a deep state coin. It might, you know, go against the Bitcoin ethos. And if you don't like that about it, don't invest in it, you know. So XRP isn't necessarily my favorite project, but I do own some, and it is exciting to see how this technology could improve the antiquated banking system. And I have no evidence that any of the people involved with Ripple are bad or nefarious or evil people. Bix seems to think so. He's a great researcher. He probably has his reasons, and after the whole EOS thing, I know he's, you know, either can't or, you know, won't talk about these type of things as in much detail as he used to. But, you know, I tend to think that, you know, Bix research is good. So there might be some bad actors involved with Ripple. And so that, anyway, I do own some XRP. During this whole since the lawsuit, I've added smaller amounts to there on some of the dips, just because looking at the rest of the space, it looks attractive to me from on the price. But also I'm trying to diversify and get some other projects. So, gosh, I can't remember his name now, but the SEC, one of the former SEC guys that Thinking Crypto interviewed, he mentioned that he thinks the SEC needs to be able to address the concerns that are in the Howey test, but come up with like new rules that more suitable for this space. So Hester Pierce, in her interview with Thinking Crypto, said that she thought that would be hard to do, but she also expressed that it would be a good idea, and that for there to be some sort of experimental sandbox, she called it. I'm not really sure what she means by that, but some way for companies to approach the regulators and see which agency or agencies rules that they need to comply with. And so let's see, Brian Brooks and Jeremy Hogan both say a settlement is likely, so I think that's interesting. So we'll probably settle and not go all the way to trial, but it could. But if you take Brad's tweets at face value, it seems like they're prepared to take it all the way to court, fight it, and win. So it'll be interesting to see what happens. So I think the big question, like Jeremy Hogan was saying, and a lot of others said in this video, was about the distribution. I don't think the question so much is XRP a security now? It's more, was it a security when they distributed the tokens? Was the token distribution a unregistered securities offering? So, that's like Jeremy Hogan was saying, this is a very stressful thing to be getting sued from the SEC. So this is going to affect Brad and Chris's mental state. So what's going to happen to Brad and Chris is a very important issue, both like with the company, will they have to step down if there was some sort of wrongdoing, and their decision making could be affected by the stress of the lawsuit. So that, I think, was an interesting point. Will we get clarity about the token distribution? Was it a securities offering? Will we get clarity on, is it a security now? And what will happen to the escrow? So those are the big main questions that everybody's waiting to find out. So I thought I would give my opinion on all those video clips I played for you guys. I hope I gave a nice, well-rounded, fair analysis. That's why I tried to bring the opinion of the haters, the army, and the experts. Hope you guys enjoyed. I got a couple more things to say, and then this video is done. It's running a little long, so I got to get it done. So see you guys in just a sec. All right, so last little update. When I started recording this video, I mentioned that some news had come out, and that news is that the Tetragon suit was thrown out and rejected by the Delaware court, and they said that there's been no determination by the SEC yet, so Tetragon's suit has been rejected as of now. Also, the SEC acknowledged the same thing, that there's been no official determination yet in response to John Deaton's lawsuit that the XRP holders have filed against the SEC. So, and I played a couple clips of him earlier on. So that's the update. Also, just barely today, Gary Gensler was approved by the Senate Banking Committee. So one step closer. Looks like Gary's going to be coming in. Is that good? Is that bad? I think it's good for the whole space. He seems, since he teaches it a whole course on it at MIT, I think it's going to work out pretty good. So I think he knows how important XRP and Stellar and some of these other projects are to the new financial system that's coming, and I don't expect anything too detrimental for XRP and for Ripple, but time will tell. Anyway, thank you everyone for watching this video. I'll just close up with those tweets. Wow, crypto lawyers will be even busier over the break, as if the Mnuchin Rule, SEC v. Ripple, and CSBS v. OCC lawsuits weren't enough. There are weeks when decades happen as they weigh. For crypto law, this was one of those weeks. I suspect both SEC moves this week are tied to Coinbase's IPO filing, which will force the open questions regarding which cryptos are securities to be answered in 2021. As mentioned earlier, in my humble opinion, the SEC will be one of, if not the, most important players in U.S. crypto in 2021. Ripple setting up a domicile in Wyoming likely won't impact its SEC lawsuit. First, securities law violations at issue in SEC's lawsuit happened long before Ripple came to Wyoming. Second, securities laws have federal preemption. They supersede state laws. In 2015, the U.S. government concluded XRP was a virtual currency. Last I checked, the SEC is still part of the U.S. government. Here's the plus side. The industry will finally get the clarity it deserves. Goodbye, Howey test. Hello, Ripple test. The Tetragon ruling, coupled with the SEC's filing in John Deaton's case, should put to rest the FUD that the SEC unilaterally determined that XRP is a security. Glad that's settled. Today, the SEC voted to attack crypto. Chairman Jay Clayton, in his final act, is picking winners and trying to limit U.S. innovation in the crypto industry to Bitcoin and Ethereum. Dan Primack, as you aptly said, the crypto industry is now large enough and old enough that it deserves a U.S. regulatory framework. Whether benefiting Ripple or not, the outcome of this lawsuit will define how the U.S. treats crypto innovation, not just Ripple and XRP. So thank you so much, everyone. Love you all. Stay safe. Remember, HODL, not financial advice. I'm not a financial advisor. Do your own research. Check with your financial advisor before investing. But HODL. Peace.